It's important for the court to have the faith of the people and to be independent. And apart from what the court itself is doing, and they've got some real problems, when you have the executive, who is the appointing authority, talking about them in political terms, the court itself becomes politicized just because of that. So we're facing a number of real challenges in our democracy right now.
That's Stephen González, the Chief Justice of the Washington State Supreme Court. Coming up, we're going to talk with him about some of the recent controversial decisions by the U.S. Supreme Court, as well as the decline in public trust of the nation's high court. Welcome to Chino Y Chicano. I'm Enrique Cerna. Stephen González has served on Washington State Supreme Court for 12 years. He became Chief Justice in 2021. In our conversation, we talk about the recent U.S. Supreme Court decision on presidential immunity, ethical questions involving Justices Clarence Thomas and Samuel Alito, talk of reforms for the Supreme Court, and the efforts of our state Supreme Court to address institutional racism. We also talk about earrings. Yeah, earrings. Listen and find out why that became a topic of conversation. You were up for re-election this year, but you didn't have an opponent, right?
That's right. The May 10th, I think, was the deadline, and nobody filed. That's a first for me.
So what do? Do you keep campaigning, or you just don't need to at this point?
I do less, admittedly, but I built out a schedule in case I had an opponent, and I'm certainly not going to cancel those things.
Yeah,
I've already agreed to do, but I'm not looking for new events.
Well, I guess there's a little bit of a congratulations here because you will most likely be on the court again. All right, so this is an interesting time, Mr. Chief Justice, in our nation's legal landscape. Let me get your take on the Supreme Court's ruling on the presidential immunity. That ruling, what you saw it did, and so the people can really understand it, because I think most people right off the top say, oh, well, now President Trump has complete immunity.
Well, certainly there are more subtleties than that. And practically speaking, what it does is it sends the case back for a determination of what things he was doing were part of his official duties and what things were outside of that. And so I don't yet know what that's going to be or whether that will get appealed as well and how that will play out. So the first thing is there'll be delay, and we don't yet know what the scope of within and without official duties is going to look like. We've dealt with similar things on a state level with what authority the governor has, what executive privilege, if any, she or he enjoys. And so these kinds of questions are typical, and they come up in a variety of contexts. For example, if you have a company that employs somebody and they get into an accident or do something that damages someone else, is the employer liable for it? So is what they were doing within or without the scope of their duties? Let's say they're driving a truck for the company doing deliveries, and they do a side trip to go pick up a couch for their cousin and get in an accident during that time. Is the employer liable because it was the company van, or is the employer no longer liable because they were doing a detour for their own private purposes, not for the company? So these decisions need to be made. They're legal decisions that are often fact-driven based on what's happening. It's a bit different when we're talking about the president. And I think on the one hand, the concern is you don't want the commander-in-chief to be worried about personal liability for difficult decisions that have to be made. On the other hand, you don't want anyone, even the president, to be above the law. And that's the tension. I think part of the problem that we're facing here is not just the ruling itself, but the whole context of what's happening among our three branches of government right now. It's important for the court to have the faith of the people and to be independent. And apart from what the court itself is doing, and they've got some real problems, when you have the executive, who is the appointing authority, talking about them in political terms, the court itself becomes politicized just because of that. So we're facing a number of real challenges in our democracy right now.
Yeah. Well, I think a lot of people would say that the court is totally politicized at this point because of the weight of the conservative voices on the court. Do you agree with that?
No,
Really?
I don't think you said totally politicized. That sounds like 100%. I think if you look at their rulings, a number of them are actually based on the law and quite defensible. Some of them are real questionable, and you wonder, given the rhetoric, and, let's talk about overturning Roe v. Wade. When you've got the person promising to appoint people who are going to do that, it sounds less like a legal analysis and more like a political choice. We don't want the court doing politics and policy. We want them doing law. So I think that's why people are doubting the outcome, for example, in that case and some others, where it's a close question and it just happens to break towards the person who appointed those very members. Now, he's not going to appoint people who have different judicial philosophies than he might favor, so it may just be that that's what's going on. But it's a problem when people lose faith just because of the rhetoric that's been employed. And I think you're right. It has been politicized more than we would like. I don't think it's 100% political. However, I think that's hyperbole.
Yeah. I always have to remember that when I talk with you, that you take my words apart. That's what every good lawyer or judge does, right? As far as what's absolute and what might be really the case. And by the way, I said some people I might see that way. I might be a part of that some. I don't know. Leading up to this, and this is something you and I have talked about before, and you brought it up briefly, is the ethical questions of the court. And it's been reported that President Biden is looking at taking some actions or proposing some actions that would look at the court, ask for term limits, implement or at least try to implement some code of ethics. What are your thoughts on that? I think there's some that believe that the court, does the court have a code of ethics at this point, the high court in this country?
Not an effective one. In the state of Washington, the justices adopted a code of judicial conduct and made it applicable to every level of court, including ourselves. We also have a state constitution that creates the Judicial Conduct Commission, which is an independent body within the judicial branch that can review, sanction, and even remove judges for misconduct. So we have a fairly robust system of checks and balances for misconduct by judges, and we've made ourselves accountable to it. I wish the U.S. Supreme Court would do the same thing. I think it's unfortunate if it requires the other two branches of government to step in. The court should do it itself. If it doesn't, then perhaps those other avenues need to be explored. I'll also say that in the state of Washington, we're televised. Every single hearing that the state Supreme Court holds is there on TVW. All of those hearings are archived. You can go back and watch those arguments if interested. I think that's been good. That sunshine has been good for the court. I wish the U.S. Supreme Court would do the same thing. It's an important institution in our democracy, and I would like more people to be able to see and watch, hear and listen to those oral arguments.
What has been the holdup from them to do this? This is just part of their tradition that they have not been, and their bureaucratic way of doing things that they don't want to do it that way?
I don't know all of the considerations for them. I've heard the explanation that they're worried about it becoming more of a show and playing to the cameras.
Yeah.
That same concern was expressed in Washington decades ago when we first started televising, and I think we mostly forget the cameras are even there. I think it's been just a positive thing. The FBI was the same way about recording their interrogations of suspects and witnesses. They were worried that somehow that would change the dynamic and that the world should just trust them. Why do they even need these cameras? They should be able to say, we're the FBI, and so believe us when we say this is what happened.
Yeah.
And then they made that change, and frankly, I think most of the agents appreciated it because now they don't have to put up with the questioning of what they said. It's right there on camera. They can just say what their impressions were and what happened, and then they have that to support it. I think in the end, that fear was misplaced, and I really think the U.S. Supreme Court justices who are worried about that, that fear is also, that worry is also misplaced.
Well, let's talk about a couple of the justices who have been under the microscope, and that has been Clarence Thomas, who has revealed that he's accepted these luxury trips from a quite wealthy guy. And then also Samuel Alito, whose wife is the one, I guess, that put the flag upside down, which someone said that represents the folks from the January 6th protests. And they also seem to be the most unwilling to accept any ethical changes. How do you read this with them? And I guess one question that I really wonder is that should they have recused themselves specifically in the presidential immunity case?
I'm going to speak generally, Enrique, in answer to your question rather than specifically as you've asked it. I don't think judges should be taking gifts. They certainly shouldn't be taking them from people who are influential or appearing before them or have a stake in what matters are before the court. They should certainly be disclosing them, and a failure to do so is serious. But I think even accepting them, regardless of the disclosure requirements, is a mistake. It undermines the faith and confidence of the people in the integrity and impartiality of the justice system. And so I just don't think those kinds of gifts should be accepted, period. Obviously, if they are, they need to be disclosed. And then I think once you've accepted a gift like that, if any party says, I question your ability to be fair given what you've accepted, I think it's your obligation to step aside from that case and not hear it.
And this is my personal opinion when it comes to both of these justices, thumbing their nose at public complaints about it or concerns about it, and really unwilling to really do anything about it as far as when these questions come up.
Well, regardless of what those two might say, a majority of the court can decide what the rules are going to be. Leadership is what's required. And I think as a body, to protect the body and the integrity of our system, the body needs to adopt rules that have real meaning.
So is that on the Chief Justice, John Roberts?
It's on every single member of any court facing such an issue.
Yeah. Across the country, do most states and their state Supreme Courts have a code of ethics? Are they televised these days? Is that pretty much an accepted practice?
On the code of ethics question, I believe universally yes. In terms of televising the arguments, I haven't kept tabs on that. I know that a number of courts now do, but I don't know what the actual number is.
Yeah. I mean, I've watched those, and I don't see any playing to the camera, frankly. They could be somewhat dry if you don't know all the cases and if you don't have a particular interest in all of that. It's like going to a city council meeting, except it's they're obviously quite different with the setting and all of that. It just seems right now the court's opinion in the court of public opinion is not good, and people I think are very wary of them and the whole political side of things. How do you see this affecting our legal system and the concern about justice and democracy in the country?
Well, our system doesn't succeed based on force and strength. It succeeds if people have confidence and faith in the fairness of the process. And when we lose that, we lose something precious. I'm glad that in the state of Washington, at least, we're doing better. I do think that we have some critics. We always will. But we're not a unified bloc that votes one way on every issue. You can't necessarily predict how it's going to come out or how one of us will vote. I think our opinions are carefully written. You'll see that we're one of the top two most cited state Supreme Courts in the nation by other states as they're evaluating and considering similar questions. And so I'm proud of that record that we've built. I think we have to do more to remain engaged with the public. But the only way that our system of justice works is if the people trust that they've had a fair shot. Otherwise, why should they care about what we have to say?
What do you think of the reports about President Biden looking to make major changes on the Supreme Court? Now, politically and all of that, and trying to get it through Congress is going to be a whole different thing. But the ideas behind it, of term limits, of, again, the code of conduct.
It's an interesting question. Every potential answer has its pluses and its minuses. In this state, we amended our Constitution years back to say that a justice cannot serve beyond the end of the year in which they turn 75. That's how I got on the court. Justice Alexander reached 75. He had another year left on his term, but couldn't serve it. And so I was appointed and then won a contested election. He would have liked to have continued serving, and he was doing just fine. I don't think there was anyone questioning his competency, his vigor, his ability to do the work. On the other hand, it led to some change and some diversity on the court that we didn't have. I think there were pluses and minuses. It's a blunt tool. And one might wonder, well, why is there an age cap for the judicial branch and not for the executive and for the legislative? Now, there are probably some folks who should have retired before they did. So there isn't a clear answer that's always right. Each state, in fact, has its own process of selecting and retaining justices. Some do election like we do on a nonpartisan basis. Some elect on a partisan basis. Some have retention elections that aren't contested. Some have an appointment process like the U.S. federal judicial system has. So there's a variety of approaches, and the problem with appointment is it's only as good as the appointing authority. So it can't be unfettered discretion in one person, because then it's up to that one person's proclivities. It's got to be something more than that if you do appointment, I believe. And for election, voters don't always know much about the judicial candidates. And unless we're really educating the public about how to select judges and who the candidates are we really doing much by having them elected? So you can't have an uninformed electorate doing the choosing, and you can't have unfettered discretion in someone who might have political reasons for their appointments either. It's got to be some check on either system.
Yeah. On the question of what the public knows about the judicial system, I think, again, it comes back to that whole thing of teaching civics and having people understand how the court system, as well as the executive and legislative branches, because I don't, if you ask most folks, I think they would have trouble telling you what's what. And that's a sad commentary on our country right now, I think.
Well, I think we need to do far better in educating about our form of government and how it functions. And I wish we did better with that and people were more engaged. One thing we have right now with the incredible polarization is people with really strong feelings, but I don't think we're moving together. We're moving more apart with them. And I think that's the wrong direction.
So from your perspective, how can we change that?
Well, each one of us, similar to your question about, is it the chief's responsibility to fix the code of conduct for the Supreme Court? And I said, well, it's every single justice. Sure, the chief has a leadership role, but each of us has an obligation. Same thing for civics. You're doing your part with your podcasts, and I know you're trying to educate about these important things. I'm certainly going to schools and talking to civic groups about the judicial system and what we do, and we need more folks to do more of that. It's the only way we share that information.
Yeah, it is one of the reasons I do this podcast, but it's also for me to learn, because I want to have insights and be able to understand what's out there and what people are thinking. I think that's an important part of it. And then, I admit, occasionally I might say what I think. But so I want to go to something that the court did in June, I think it was June 4th, 2020, when the court published a letter basically out to the public, and it really dealt with the issues. And this was during the time of George Floyd, after all of that. and really expressing its concern about fairness in our legal system, and particularly as it affected African Americans. But I think your intent, you can correct me on this, really was fairness for everybody. Where are we now? Because it was quite a feat, actually, to have basically all the justices sign this letter to express their concerns. And I think, you probably grabbed some national headlines on that as well. Where are we now with that?
We're not the only state Supreme Court that issued a letter. We were one of the first and perhaps one of the stronger in wording of the statement that we made. And it was a call for the entire community, especially lawyers and judges, to be involved in taking responsibility for the history we've inherited and ourselves created, and making sure that we're living up to and coming closer to the promise that we're all entitled to justice and fairness in our courts. I think we have to admit that we haven't been perfect there. We have been doing things not just since the letter, but before, during, and since then. And I'm proud of the progress that we've made. We've taken on major initiatives, and this is outside of just the cases we decide. It's also the rules that we pass and the research that we have conducted and the boards and commissions that we have that wrestle with these difficult problems and try to provide data and research for us to better understand what we face. And so we've done things like bail reform that tries to make it a fairer system of who gets out and who remains in, because you don't want the public endangered by letting people out who are a risk to others. You also don't want to hold people in custody unnecessarily. It does change the outcome and the rate of conviction just by virtue of those release decisions, which disproportionately in the past affected people without the means to post bail. We've taken on changes in the rule side, the legislative function, if you will, of the judicial branch, and passed rules like General Rule 37, which changed the way juries are selected, or perhaps more accurately, the way potential jurors are deselected, because the previous way of selecting juries resulted in the disproportionate removal of people of color from the panel. And we've changed the rule to make it, I think, a more objective standard. And in fact, it's reduced the removal of people of color who are otherwise qualified to serve. And this is important because although you don't have a right to serve on a jury if you're in the panel, you have a right not to be removed because of an illegal reason, such as your religion, your race, your gender. And so that helps, I think, improve the confidence. But more importantly, all the studies of juries have shown that a heterogeneous group makes better decisions than a homogeneous group. They're more likely to read the instructions from the judge. They're more likely to examine the exhibits given them in evidence. And they're more likely to talk to each other about the questions that they have to answer in a case. It might take a little bit longer, but I think that one sacrifice of efficiency is worth it for all the other gains. So those are the kinds of changes that we've embarked on. We have adopted new rules that allow hybrid and remote appearances for people, which saves travel time and time away from work and childcare and parking and all the other things. We're right now considering proposals that have to do with the number of cases a public defender can take on at one time, and we'll have a comment period and a public hearing. I think our first public hearing is September 25th, which I'll preside over, where we hear input from the public and stakeholders about those proposals. We're working on improving the pipeline for attorneys. Some people think we have too many lawyers. The truth is we don't have enough, especially in parts of the state where we have a shortage, particularly of prosecutors, public defenders, and civil legal aid attorneys. I think law school is too expensive, and so we've been working with the deans to try to reduce the cost, or at a minimum provide scholarships, incentives, and loan forgiveness for those graduates who want to go into public service law. We're trying to change the way you become a lawyer and make it a more equitable process that actually chooses people who are going to be competent rather than calling people out for reasons that aren't really associated with merit. So there are a number of things that we're doing to try to ourselves live up to the rhetoric of our letter of June 4th, 2020.
How did the idea of writing this letter all come about? Was this your idea initially, or was it others on the court?
It wasn't my idea initially. Justice Stevens was chief. It was her idea to write a letter. And I have to admit with some chagrin that my first reaction was, I'm not so sure we should issue a letter if we don't mean it, if we're not going to live up to it. Because just another rhetorical statement about how we think racism is bad doesn't do much for me if we're not actually going to make changes. Fortunately, others on the court, like Justice Yu, who took the lead in drafting it, said, well, let's do our best. Let's give it a try. And I was very pleased with the draft, and others of us had some edits that were made, and ultimately we came up with a product we all 9 signed. And I'm glad that I was proven wrong, that we issued that letter with a call to action, and that we've been trying our best to live up to it. Sometimes better than others, but we've made some real changes. We've overturned convictions for members of the Yakama Nation that were in violation of the treaty. We repudiated the doctrine of discovery, which led to subjugation of indigenous populations. We've changed rules to make them gender neutral, where before they weren't. We've passed rules that have to do with limiting legal financial obligations. We've done a lot, I think, to live up to that rhetoric in that letter, and I'm proud of my court for doing that.
So in the case of like the Yakama Nation, the tribal nation there, was that a case that was before the court, or was that something the court went back and looked at past cases that you thought, okay, maybe we need to revisit this?
Somewhere in between those two things. We didn't do it on our own. Jack Fiander, who's an attorney and I believe also a Native American enrolled member, brought it on behalf of the family members, the descendants of Mr. Wallahi, who'd been convicted. And 2 of my colleagues opined that we actually didn't have authority to hear the case because Mr. Fiander didn't have standing. And we found that the family members had enough of a stake in the reputation of their family name and the outcome, as well as the tribe itself, who urged us to take it, for there to be standing and authority for us to hear the case. We didn't agree on that unanimously, but 7 of us did take that case and overturn that conviction. It was a conviction on our books that we had issued, and we were the only ones with the power to withdraw that mandate and overturn that.
And what was the conviction about?
Yeah, he had been hunting deer on Yakama land and was convicted. And at the time, about 100 years ago, the Supreme Court, my court, wrote that the treaty didn't have to be respected because when Washington became a state, that prior agreement with the tribes in the United States went away and it was superseded. That's, of course, wrong legally. That treaty remains in effect. It is a binding document. It's the supreme law of the land, in part, along with the Constitution and other obligations. And so that was incorrect. In addition, the opinion used very dismissive, disrespectful, and racist language about tribes. And so we wanted to say that that's not language that we can countenance. We have to disavow it and say that's incorrect and harmful. And so to me, it was important. That was a case I had long recognized as one that was one of the worst decisions that I think this court had ever issued. So I wasn't unhappy to have the chance to say so in writing.
Are there other cases, or do you have anyone on the court that is looking into cases that could the court might want to consider again?
Well, I've had a list for a while of cases that I'm concerned about. One was the Evergreen Cemetery case, which we also overturned, which is a case in which the court said it was okay to prohibit the burial of a child of color next to a white child in a cemetery. It also included disparaging comments about civil rights workers and Black people. And so we also disavowed that language and overturned that case. Well, because the legal question, which was a different one altogether and had to do with initiatives, was incorrect as well. And so we were making a point of law, but in the meantime, we're also able to say, and the rationale and the comments in that case are not appropriate and are not good law and can't be cited as precedent any longer.
Do other justices have a list like you?
I don't know.
Okay. Well, I mean, I think this is important. It, in many ways, it rights a wrong, or at least takes a look at things in our country that aren't great. So anyway, I'm glad to hear that.
Well, if I could say one more thing on this topic, we talk about the need for faith and confidence.
Right.
I think that faith and confidence has to reside in all of the communities across the state. And to the extent that the court has said disparaging things about ethnic groups, how do we expect them to have faith in us unless we revisit that and say that was wrong? You're just as entitled to justice as everyone else, and we're sorry we used that language in the past. We dedicate ourselves not to do it again in the future. I think that's really important. And if that alienates some folks in the majority who think that we're overstepping, I'm sorry. I want them to expand their thought and consider that this court is a court for everyone, and this is actually a step towards rebuilding confidence in a more broad way than before throughout the whole state. It's part, I think, of acknowledging past mistakes and being a better court in the future for everybody.
Have you heard of Project 2025?
Yes.
Okay. What concerns you about it when it comes to the legal system in our country, and how it might affect not only us nationally, but within our states?
Well, we're treading on some fairly political issues here. I'm going to say I'll go back to my statement about the importance of the independence and integrity of the judiciary. That it's important that each branch respect the other two branches. And I'm not so sure that all aspects of that project do so.
Are you concerned about the direction, well, I guess, of the country? And I'm again going to look at our nation's Supreme Court, and deep concerns about its shift to the right and what that might mean, particularly if Donald Trump is reelected. I'm not sure how that would affect, or is elected again, our states. But are you concerned about that?
Well, it's going to affect every state, regardless of how the election goes. It's important to build and protect an independent analysis of state constitutional law. And we've been doing that regardless of what's happening with who occupies the White House. The state cannot provide less protection to constitutional rights than the federal Constitution provides, but we can provide more. And in many instances, we do. Article 1, Section 7 of the Washington Constitution provides more protection than the Fourth Amendment to the U.S. Constitution. It has an explicit protection of individual privacy, which the U.S. Constitution doesn't have. You can't be disturbed in your private affairs without authority of law, our state constitution says. Now, that's resulted in some things that some people think are good and some that they think are bad. Sometimes it means that law enforcement has less right to interrupt your daily comings and goings than could happen in another state that doesn't have those protections. I think it's critical that we continue to develop, protect, and maintain that independent analysis of the Washington State Constitution.
Do you think our democracy is in a crisis state?
I think democracy is always fragile, and I think it's important that we redouble our efforts to make sure that we're living up to those ideals. Rhetoric isn't going to help. Partisanship isn't going to help. The fundamental principles, even if we didn't mean them when we asserted them in our founding documents, are what matters. Justice for all, liberty for all, free speech, regardless of what we think of that speech. These are bedrock principles that we need to protect. And I'm not sure that we're cleaving to the universality of those rights as much as we should be.
You know what I always like talking, why I like talking with you? It's because you always make me think beyond these, how questions I might ask can be very general, but when it comes to the specifics, and I realize, as a Supreme Court justice of our state, you have to walk a kind of a fine line here, but it makes me think more about the nuances of everything, and drives me crazy, but I sort of like it, so I appreciate that very much. I got to ask you one thing, and I noticed that you have an earring on your left ear. When did that, is that any of your justices say, hey, what's up with that?
It's actually an ear cuff.
Oh, really?
There's no piercing. It clips onto ear.
Okay.
And I got it when I was in college. In fact, I think my mom got it for me when I was in college, and I've worn it off and on ever since.
Really? Have you worn it in court?
I have. Just because of gender norms, women are generally freer to have more, what's the word? To accessorize more than men do.
Yeah.
I think we need to break out a little bit, and not be quite so gender normed. I like this, and so I've been wearing it. I've worn it on the bench through the pandemic, and personal choice.
I like it. And you know what? I want to get one of those because I want to see the reaction of my children, which I could already hear already.
It's going to be positive. Enrique, I guarantee.
How did your boys? So you have two boys. So what did they think?
Oh, they're both cool with it.
They were cool? How about your wife?
Well, I had it when she met me 34 years ago. So
maybe that was a draw. I don't know.
No surprise there.
Okay. Before we go, I want to ask you one other question. We don't get to see each other that often or talk that often. But, back in 2012, 2013, now I did a documentary, which we were part of, that was looked at Latinos and the changing face of Washington. And obviously we talked about some of the issues that you faced after you were appointed to the court and running, and just the fact of, I called the segment González is an American name. And I'm wondering, 11 years later, when you were out in the campaign trail, was that still an issue?
It's still an issue, and it's still a concern for me. This year, Justice Owens is retiring. Apropos of our previous discussion, she reached 75 this year and can't serve beyond the end of this year. So it's an open seat. And one of the candidates for that seat is a good friend of mine, Salvador Munguia. Now, his name doesn't have Z's in it, and some people might be confused and not know what it is, but it's actually Munguia. It's
Munguia, yeah.
He's Latino on his dad's side and Japanese on his mom's side. And I'm a little worried about how voters might take that if they don't know enough about his background. He's an extremely well-qualified person and has dedicated his work to public service and improving the justice system. But I worry a little bit about how people will respond to his complexion and his name.
Yeah. And I know that one of your big challenges was when you were campaigning in Central and Eastern Washington. And it's a statewide position, so there's always a challenge there. Well, I kind of hope that at some point in time we'll get beyond all that.
I hope so,
nice.
And I want voters to vote based on credentials. And if, after the review of the credentials, they don't pick me, that's fine. But I don't want the choice to be based on demographics for any of our races.
Washington State Supreme Court Chief Justice Steve González, thanks again so much, and we'll talk again later, okay?
Thank you. I look forward to it.
All right.
The Chino Y Chicano podcast is available on your favorite podcast provider.
You can watch the video version on YouTube, and Converge Media, a leading producer of culturally relevant content in the Pacific Northwest. We'll talk more later.